The difference between attempted murder and GBH is essentially the intent. For attempted murder, the prosecution need to prove that somebody intended to kill, whereas for GBH, the prosecution need to prove that somebody intended to do really serious harm. Generally speaking, it's considered more difficult to prove an offence of attempted murder than it is GBH, whereas if there is a victim who has what can be considered really serious injuries or who has suffered really serious harm, then it might be that that is easier for the prosecution to prove. Both carry maximum sentences of life imprisonment. However, the ranges for each of the offences are significantly different. Attempted murder is the more serious offence, and so that carries a penalty of between 3 to 40 years, whereas Section 18 GBH carries a penalty of between 2 to 16 years imprisonment. The more serious the offence, the lengthier the custodial sentence that will be imposed. Offences involving factors such as premeditation or use of a weapon would be considered far more serious than those involving, for example, excessive self-defence or offenders who have significant mental health conditions that have contributed to the root cause of their offending. The distinction is an important one because when concerned with an attempted murder, the prosecution need to prove what the offender's intention was. There needs to be an intention to kill, and so it's very much focused on that mental element. The mental element is equally important in relation to a Section 18 GBH because the prosecution need to prove that the offender intended to cause really serious harm. However, there is also a significant emphasis on what harm was caused and whether that harm can be said to be really serious harm or not. Obtaining expert legal advice is really important. Although it may seem as though some of the distinctions in these cases are not particularly complex, the reality is that the consequences can be significant, and although it may sound simple, it often isn't that simple. You need to make sure that you have instructed a solicitor who has experience of identifying what the issues are likely to be, working with experts in relation to injuries or other medical evidence, and who have experience in potentially discussing the situation with the Crown Prosecution Service or making representations to the Crown Prosecution Service to ensure that the appropriate charge has been laid and that it properly reflects the evidence that's available.